Administrative law and its impact on the environment. Environmental law falls under the category of administrative law because an administrative agency creates and oversees the regulations that are promulgated from the original statute. Usually, administrative agency is established by legislative branch via a statute called an enabling statute. In some instances, executive orders have been used to establish administrative agencies. Agencies are expected to execute specific duties of public interest, convenience, and necessity. To do this, they are given various legislative, executive, and judicial powers. These powers make administrative agencies the fourth branch of government. However, since these are delegated powers that remain under the control of traditional branches of government, they are not entirely independent. For Chapter 3, you should expect these learning outcomes. Explain the creation of and functions for administrative agencies. Distinguish among the different forms of rulemaking. Describe the process of administrative agency adjudication. Recognize the limitations that influence rulemaking. Attribute how the branches of government limit agency powers. Identify the unique role for agencies regulating the environment. Review the history of the EPA. Most agencies are formed by enabling statutes from Congress wherein Congress grants a specific scope of authority to the agency. In more rare cases, administrative agencies are created via executive reorganization plans. These plans are enacted via an executive order. In either case, the purpose is to authorize the power for the agency and define the limits of that power. Quasi-legislative powers are granted so that agencies can create rules. Rules are similar to laws in that they control individual and corporate behavior and can have civil and criminal consequences. Executive powers are granted so that the agencies can investigate rule violations. Judicial powers are granted to settle disputes with the agency and other parties. Within the executive branch, there are 8,000 to 9,000 Senior Executive Service SES and exempt EX appointments. The SES is a core of men and women who administer programs at the top levels of the federal government. Positions are mainly managerial and supervisory and fill the top positions of federal administrative agencies. Exempt appointments are appointed by the President with the consent of Senate, such as secretaries of departments and agency directors. These individuals are not elected, which ideally insulates them from political pressures. People in these positions can significantly affect the enforcement of administrative law, including environmental law. The people appointed to federal agencies may or may not have any experience with that field. Most will be appointed with experience from that agency. However, some are entirely political appointments with no experience in the agency or subject matter. Administrative agencies are granted quasi-legislative powers, allowing them to create rules, also called regulations. That is, administrative agencies promulgate regulations. Promulgation is when an agency puts a rule or regulation into action. The Administrative Procedures Act of 1946, which we discuss later, describes rulemaking. The precise nature of rulemaking process can happen one of four ways. It may be outlined specifically in the enabling legislation. Otherwise, rulemaking can follow formal, informal, or hybrid models. Informal rulemaking is also called notice and comment rulemaking. An informal model is used when no other form is prescribed. The proposed rule is published in the Federal Register which can be commented on by interested parties wishing to participate in the agency's decision. However, in all rulemaking processes, public participation requirements may be exempted if they are related to military and foreign affairs, agency management or personnel, public property, loans, grants, benefits, or contracts, interpretive rules, general policy statements, and when public interest is impracticable or unnecessary or contrary. After comment and possible testimony review, the final rule is published in the Federal Register and becomes effective at a minimum of 30 days later. This model is cost and time efficient, but comments from biased parties may go unopposed and still be considered, and there will not necessarily be a transcribed record of the process. The formal model is used when a hearing and transcript are required as indicated in the enabling legislation or a particular statute. First, the proposed rule is published in the Federal Register. Then, there is a recorded public hearing with witness testimonies and cross-examination discussing the pros and cons. An official transcript of the hearing is kept. This hearing is considered by the agency, published as formal findings, and the rule is or is not promulgated. The final rule is published in the Federal Register, and ultimately, it's codified in the Code of Federal Regulations. A disadvantage of this model is that hearings and transcripts can be costly. For this reason, formal rulemaking is only used when prescribed. It is never interpreted as the expected model for rulemaking process unless explicitly stated in the law associated with the rulemaking process. Hybrid rulemaking attempts to combine the best features of informal and formal rulemaking. The starting point, publication in the Federal Register, is the same. This publication is followed by the opportunity for submission of written comments and then an informal public hearing with a more restricted opportunity for cross-examination than in formal rulemaking. The publication of the final rule is the same as for the other forms of rulemaking. Regulated negotiation is a newer form of rulemaking that seeks to reduce challenges to regulations and increase structured bargaining among interested parties. A mediator leads bargaining meetings with representatives from the interested groups and agency. The agreements reached are forwarded to the agency. The agency is then expected to publish the compromise as a proposed rule in the Federal Register and follow through with the requisite rulemaking procedures. The agency, however, is not bound to do so. If it does not agree with the proposal the group negotiated, the agency is free to try to promulgate a completely different rule or a modification of one obtained through the negotiation. The rationale for the use of regulated negotiation is the same as that for more frequent use of mediation over litigation from Chapter 2. A compromise created by interested parties is more likely to be acceptable to those parties than a rule created by an authority. This approach is preferable in cases where compromise is possible. In cases where there are way too many interests to expect resolution via mediation, or when there needs to be a decision between different principled stances, this is not the most appropriate approach. The benefits to administrative rulemaking are obvious given that it would not be expedient for the legislature to issue rules itself. Some are critical of rulemaking due to the fact that the officials at the agencies, while not subject to the same political pressure of elected officials, may have pre-existing relationships with industries that they regulate. Not surprisingly, the agencies hire people with expertise in a given industry. Thus, you can end up with people from a given industry with biased approaches to regulating that industry. When this is pervasive across the agency, it is said to be a captured agency. Central to all decision-making about environmental issues is the concept of scientific uncertainty. The causes and/or consequences of pollution are likely to be unknown. There are time lags between exposure and the consequences that manifest in human health and ecological impact. Thus, it's difficult, if not impossible, to ascertain the impact of a given pollutant. Further, there is disagreement over how much certainty is necessary to trigger regulation. To make things even more complex, a single pollutant may have uncertainty, but also the synergistic effects of multiple pollutants are poorly understood. Environmental rulemaking should balance the immediate cost associated with compliance for a given regulation versus the long-term gains, perhaps for future generations, provided by the regulation. How much should we sacrifice in the present to protect those in the future? Setting compliance requirements in the face of potential legal challenge by the regulated industries or by the environmental interests pushing the agency to act runs the risk of causing agencies to choose strategies that might not satisfy either group or might not be very effective. Businesses stationed in the United States may be at a competitive disadvantage if they have rules that cost them greater time or money than businesses outside of the United States. Furthermore, U.S. companies may move to seek reduced regulation and other costs associated with materials and labor. Finally, the will of the public to support regulations is greatly impacted by the economic state of the country. Thus, regulators are more likely to see greater public acceptance of rules during a healthy economy with low unemployment. Adjudication is the legal process of resolving a dispute. Similar to rulemaking functions and agencies, the Administrative Procedure Act defines the processes that are to be followed during adjudication by an agency. Those procedures can be altered based on the agency's enabling statute. An administrative agency adjudication is overseen by the administrative law judges, or ALJs. Adjudication begins with an investigation and an agency filing a complaint. The party against which the agency is taking the action is entitled to notice the time and place of the hearing. To notice of the time and place of the hearing, the authority and the agency it is relying on, and the matters of fact and law asserted. After that party receives the complaint, they file an answer. If a settlement is not reached, then there is a hearing in front of an administrative law judge, at which point the administrative law judge issues a decision. The decision can be appealed, and top-level representative of the agency issues the decision. That decision can be appealed to the Circuit Court of Appeals. Agencies can issue compliance orders which require immediate action or movement toward compliance with punishment for non-compliance. However, the compliance orders are also appealable. Agencies can also issue corrective orders which are similar to specific performance by court orders. The number of cases and appeals is so high that there are special boards organized to handle them. Administrative adjudication is relied on more than trials because the former requires less time and cost. Environmental laws can contain measures of administrative, civil, and criminal action. Administrative penalties are usually the least of the three to encourage early settlement. Additionally, to motivate citizens, Most federal and state agencies involved in environmental enforcement have reward programs to encourage citizens to bring forth evidence in cases of violation. Other agency activities involve business and individual advising, research, issuing permits, property management, and supplying information. Agencies are limited by some federal statutes. The most pervasive is the Administrative Procedures Act, which is a statute that governs the way administrative agencies of the federal government may propose and establish regulations. The Act also sets up a process for the United States federal courts to directly review agency decisions. It is one of the most important pieces of United States administrative law. The Act became law in 1946. The APA applies to both the federal executive departments and the independent agencies. Two other acts are especially helpful in keeping agency action open to the public. Preventing secret, arbitrary, or capricious activity. The Freedom of Information Act and the Government in Sunshine Act. The Freedom of Information Act requires agency information publication to allow public access to proposed rules, policy statements, staff manuals, and policy interpretations. The Government in Sunshine Act requires business meetings to be open to the public if the agency is headed by a collegiate body when a quorum is present. A collegiate body has two or more people, with the majority being appointed by the President and approved by the Senate. The Federal Tort Claim Act allows private parties or citizens to bring claims against the government for improper actions of federal administrative agency employees. Damages can be sought for torts or civil wrongs. The Act forces an agency to waive sovereign immunity for its tortious actions and those of its employees. Tortious actions under this Act include assault, battery, abuse, prosecution, and false arrest. In the executive branch, the President appoints agency heads. The President may also issue executive orders or mandates, and the Office of Management and Budget recommends agency budgets. In the legislative branch, Congress exercises oversight and investigative power to determine whether agencies are properly executing their intended functions. Termination and amendment powers, approval power over budgets, advisory powers on administrative head nominations, and powers in the Congressional Review Act of 1996. Budget powers are the greatest limitation on agency actions. The Congressional Review Act requires 60 days before a regulation takes effect after promulgation. In that time, Congress is allowed to reject the rule if a majority passes a resolution of disapproval. The resolution of disapproval nullifies the relevant regulation if it is signed by the President or if his veto is overridden by Congress. The judicial branch acts to ensure the agencies adhere to their statutory requirements. Courts can reverse or modify agency rulemaking or adjudication actions when a legal complaint is filed by a party that deems the agency rule invalid. A rule is invalid if the agency's enabling statute was too ambiguous and scope was not limited, or if the agency acts beyond its given scope, or if the agency violates a constitutional principle, or if the agency does not follow proper rule promulgation procedures. These situations, however, are rather unlikely. Executive agencies or cabinet level agencies are usually within a department of the executive branch. Their functions are broader in nature and considered social regulation. The President appoints heads of the executive agencies. These appointed heads can be discharged at any point or for any reason by the President. Independent agencies are usually not within any department. The independent agencies tend to be called commissions and have more narrow focus on economic regulations. Independent agencies are headed by a board of commissioners, such as a chair. The President appoints the board with the advice and consent of the Senate. The commissioners have a fixed term that cannot be ended without reason. There may not be more than a simple majority of either political party on any commission. Hybrid agencies have shared qualities of executive and independent agencies. The EPA is an example of this. It is independent of any department, but the administrator is subject to the presidential preferences. The EPA was created by a presidential reorganization order in 1970. Its original functions were to control air, water, solid waste, pesticide, radiation, and toxic pollution in coordination with the state and local governments. It is one of the largest federal agencies. The EPA's structure was designed to encompass all aspects of pollution control. The head administrator, helped by the deputy administrator, sets overall policy. According to the EPA website, there are 3 assistant administrators, 12 offices, and 10 regions with offices around the United States. These components are meant to help with research, standard and policy setting, monitoring, and enforcement. Texas is in Region 6. The EPA's effectiveness is influenced by its ability to work with other federal and state agencies. Combining resources and efforts can help agencies achieve mutual goals, enforce higher standards, and support federal initiatives. A prime example of this is the U.S. intelligence community, which is comprised of several agencies with a common goal of national intelligence and security. The Department of the Interior is charged with balancing preservation of natural resources, especially land, and economic growth. It contains the Bureau of Land Management, which manages public lands and resources mostly in Alaska and the West, the U.S. Fish and Wildlife Service, which protects wildlife and habitats, and the National Park Service, which conserves natural and historic lands. The Department of Interior also administers Indian land programs. The Department of Agriculture includes the U.S. Forest Service, which manages forests and grasslands. Like the Department of the Interior, it strives to balance natural resource use and conservation, but its efforts are focused on a particular type of wilderness. The Department of Labor includes the Occupational Safety and Health Administration, OSHA, which is responsible for health and safety in the workplace. The National Institute for Occupational Safety and Health, NIOSH, OSHA's sister agency, focuses on research, and the Mine Safety and Health Administration. Environmental agencies are also present at the state and local levels. The U.S. EPA is obligated to delegate responsibility for operating many federal environmental programs to states that meet certain qualifications. State administrative agencies are responsible for operating these programs. The states set up their environmental agencies in a variety of different ways.